I'm just your average parent trying to do right by my kids. Never thought I'd have to, deal with something like this. It was a regular Tuesday afternoon. The kids' toys were scattered everywhere. Then there was a knock at the door. My heart sank when I saw who it was.
Hello, I'm from Child Protective Services. We've received a report and need to inspect your home.
I didn't know what to do. They wanted to come in, look around, talk to my kids. My hands were shaking. I felt like I was doing something wrong even though I knew I wasn't. But then, I remembered something I'd read online about knowing your rights. I took a deep breath and said, "I'm sorry, but unless you have a warrant, I can't let you in." The CPS worker looked surprised. They weren't used to parents knowing their rights. It wasn't easy, but I stood my ground. I protected my family's privacy that day. Remember, when CPS knocks, know your rights. It can make all the difference.
CPS took my neighbor's kids last week. Here's what I wish she knew beforehand. She had no clue what her rights were and completely panicked. That's exactly what you can't do. The difference between keeping your kids and losing them comes down to being prepared. There's this book, Stay Calm, CPS is Coming, that breaks down everything you need to know. Education isn't just power, it's protection. Grab it on Amazon or check cpsbreakingnews.com. Don't wait until it's your door they're knocking on.
Family is the most important thing we have.
It's about time we stand up for the kids.
Tiff and the Punisher, they won't back down, screaming out loud in every town. Stand against the system that's gone insane, fighting like lions, don't feel no pain. Abolish CPS, their rally cry. No kids for cash, we won't comply. Make parenting great, let's take a stand. Tiff and the Punisher, hand in hand. Voices heard, don't tread on me. Taking back rights, we will be free. Constitution in our veins, breaking these chains and claiming gains. Abolish CPS, their rally cry. No kids for cash, we won't comply. Make parenting great, let's take a stand. Tiff and the Punisher, hand in hand. CPS, stealing kids, they gotta go. Fight the good fight, let everybody know. We'll raise our fists and say aloud, no more silence, join the crowd. Abolish CPS, their rally cry. No kids for cash, we won't comply. Make parenting great, let's take a stand. Tiff and the Punisher, hand in hand. Hand in hand. CPS, stealing kids, they gotta go. Fight the good fight, let everybody know. We'll raise our fists and say aloud, no more silence, join the crowd. Abolish CPS, their rally cry. No kids for cash, we won't comply. Make parenting great, let's take a stand. Tiff and the Punisher, hand in hand. They are taking our kids every day. A child a minute, no one.
Hey, everybody. Darren, don't worry about the music because Mr. Ramey's here and we're going to start. But I want to go over, before we have Mr. Ramey come up, I do want to go over the paperwork that we're giving out today, and also on our website. So if you've registered and you want a copy of everything that Darren and I have, just email us and we will make sure you get it out. So the first thing is the warning that you're going to send to the school with your children, and you're just going to cut it out. I had to look this up because I didn't know how much laminate costs. You can actually use parchment paper and wax paper for laminate. So anyway, you're going to cut this out, and in this little box right here, you're going to put your name and your phone number. And what it says is that this is a warning that the child is under 18. They are invoking their Fifth Amendment right and choose not to answer questions. The Fourth Amendment right, thank you, Darren, to any searches or seizures of their belonging or in their living space. And their First Amendment right to remain silent is, wait a minute. I think I got it wrong. Oh, and their First Amendment right to be questioned with their parent or legal guardian. And then the big bold letters that are on the back, it says, warning, you are violating my rights. So make sure that if you have kids going to school this year, you make sure that you get a copy of this because this is very important. The other one that we have, and I've already done this, and once you do this, the Declaration of Truth as the parent for your child, once you fill it out, have it notarized, you have to send it to your local school board, and you have to send it to wherever your state school board is. Like ours is in Richmond, Virginia. So you have to send a copy to them, and then you give a copy to the principal. And it pretty much tells them that you as the parent do not contract with CPS, even though the school contracts with CPS. And it tells them that no one, absolutely no one is allowed to talk to your child. And it names everybody, CPS, the police, just everybody, except for educational purposes only. If they go outside of that realm, in big bold letters, it says, you will cause harm to my family and I will sue you under Title 18, USC 241 and 242, which is deprivation of rights under color of law. When I did this, the school said, Ms. Wise, nobody's going to talk to your grandson. And I told them I appreciated that because if they did, I would sue them. So if anybody needs copies of this, let Darren and I know. We will get it out to you. And without further ado, because now we're running late, as I told you, the National Parental Rights Organization, the president is here, and I'm going to let him speak. If anybody has any questions, type them in the comments, and we can answer them after the live or during the live. Here we go, Mr. Ramey.
All right. Good afternoon. Thank you for the opportunity to come today and share with you. Before we get started, Parental Rights Foundation is a national nonprofit. I need to tell you up front what we're not first. We're not a law firm. We don't have lawyers on staff, so we can't defend families in court cases like that. What we are is a 501c3 nonprofit education organization. We educate the general population. We educate judges through amicus briefs. We educate lawmakers and promote good policy at the state and the federal level. So that's what we're about. And so what I want to do today is to look at unpack some strengths and weaknesses of American parental rights. And for the end, I'll get down to more how we're helping parents in the CPS situation, and what you can do to help us help them and help you. So, but first, I want to start off, parental rights are what's called a prior right. And that means it's a right that existed before there was government. When we founded the Constitution, parental rights already existed. And in fact, there's a United Nations agreement from the 1940s, one of the earliest ones, that said parents have a prior right to choose the form of education that their children will receive. Now, that's only one piece of parental rights, but they recognize parental rights as a prior right, a right that existed pre-government. And so it's the government's role not to give us that right, it didn't come from them, but to recognize and protect that right. So some of this will be a little bit frustrating, to be honest with you, because you and I both know that how parental rights are treated at one level is not necessarily the way they're treated all the way down. I want to go over some Supreme Court stuff to get us started. And this is where if you took your case all the way to the U.S. Supreme Court, you have a really good chance, because the U.S. Supreme Court has a very high view of parental rights. That's not the day in and day out family court view in a lot of parts of the country. So, but parental rights in the U.S. Supreme Court started in 1923, was the first case, because before that it just wasn't questioned. When it finally was questioned, the Supreme Court said this: without doubt, liberty, it's referring to the Liberty Clause in the 14th Amendment. Liberty denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. That was, again, 1923, Meyer versus Nebraska. And I want to just highlight that bit right in the middle: to marry, establish a home, and bring up children. That's part of the liberty that's guaranteed by the 14th Amendment. It's our right to do that. Now, in case that wasn't clear enough, 2 years later, in Pierce versus Society of Sisters, they said this: the child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Now, both of these cases, Meyer and Pierce, dealt with education. In Meyer, the state of Nebraska had said you can't teach children German. It was shortly after World War I. So they said you can't teach anything in German because Germany was the bad guy in World War I. And so some parents who wanted their kids to learn German and some teachers who wanted to teach German took that to the court. In Pierce versus Society of Sisters, the state of Oregon had passed a law saying that all students had to go to public schools. And that's because of immigration and so forth, and they were concerned about Catholics and the Irish and the immigrants. They wanted everybody to learn and become molded by the state. And the Supreme Court said, here, the child is not the mere creature of the state. And so parental rights again came to the fore. And then it jumps to 1972, Wisconsin versus Yoder, and this was Amish. And again, it's an education case. The state of Wisconsin had was requiring all students to go to school through high school, and the Amish wanted their children to go through middle school and then finish their education in the Amish community, in the Amish way of life, and so on. And the Supreme Court acknowledged that states have a big interest in making sure that folks are educated, but the primary role of parents in the upbringing of their children is now established beyond debate as an enduring American tradition. They sided with the parents there. And this word primary, the primary role, what it means is the parents come first. The state has a secondary role, but the parents have the primary role. And so it's not just, this is one role the parents fill. No, this is talking about the fact that the parents are in the driver's seat. The parents are in that primary position, that primary role. And that was more than 50 years ago. So you think parental rights are fairly well established at that point at the U.S. Supreme Court level. And even then, It's not really making its way down to the family courts very well. But then we get to 2000, and Trotzel v. Granville, the liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. And Trotzel v. Granville was really splintered. It had to do with, again, it was, no, this is the state of Washington. I was about to say Oregon. It's the state of Washington. And they passed a law that allowed grandparents to sue for visitation rights of their grandchildren if the spouse, who was the child of the grandparent and the parent of the child, was deceased. The difficulty there is that the living parent still has parental rights. And so then the question was, can the state allow for, and it didn't just allow for grandparents, but for other third parties as well, to sue, to overthrow the parent's right to make those decisions and let the state decide what's best. The Supreme Court was really splintered on this case. In fact, this quote is from the Trotzel v. Granville decision, but only 4 justices were on this decision. The parent won, but it was a collection, if you will, of this decision by 4 of the justices, and then 3 other justices with individual concurring opinions that said, yes, I agree the parent should win, but I disagree with some of the discussion. And so this 4-judge decision said that when parental rights are involved, they should be given some special weight. And that's a quote from the court, some special weight, which they didn't define, and they left things really ambiguous. So Justice Thomas concurred. He was one of those who agreed that the mom should win, but for different reasons. And he pointed this out. He said the opinions of the plurality, that's the 4-person that we just read, and Justice Kennedy and Justice Souter recognized such a right, that is, that parental rights are fundamental. But curiously, none of them articulates the appropriate standard of review. I would apply strict scrutiny to infringements of fundamental rights. Strict scrutiny is that highest level of judicial review, where the state has to have a compelling interest that's met by the least restrictive means. And so Justice Thomas is saying, you know, we got the right, but we didn't give it some special weight is not enough. It should be strict scrutiny. That the state cannot mess with that right except for something the state is obligated to do and can't do by any other means. For instance, keeping a child safe. So in answer to that case and the ambiguity from the Trotzel decision, parental rights was founded, parentalrights.org was founded in 2007 with an aim to create a parental rights amendment to the U.S. Constitution that would take those rights that have been recognized by the Supreme Court for 100 years, put them right into the black and white text of the Constitution so that they can't be changed by shifting ideologies in the court, so that they can't be just dismissed, and so that they definitely receive that strict judicial scrutiny that Justice Thomas was talking about. The Parental Rights Foundation arose out of parentalrights.org in 2014 because parentalrights.org very simply is a C4 political organization, and it's easier for people to donate to a C3 where their donation is tax deductible. And since so much of what we do is really education and not politics, today we do all of our work under the name and the structure of the Parental Rights Foundation. So if you go to parentalrights.org, that website is now a website of the Parental Rights Foundation dedicated to this parental rights amendment. And the amendment's very, very brief and very straightforward. But keep in mind, those of you who wrestle with law and are working on policies and that kind of thing, bear in mind that that a legislation has to be detailed, has to provide definitions, has to cross every T, dot every I. And amendment language, constitutional language, is broad and basic, and it kind of hits with a major punch, but it's not trying to get at every teeny tiny detail. And so it just simply says the liberty of parents to direct the upbringing, education, and care of their children is a fundamental right. And that echoes those parental rights cases that we just looked at. And then it says the parental right to direct education includes the right to choose as an alternative to public education, private, religious, or home schools, and the right to make reasonable choices within public schools for one's child. And we're going to come back to that last piece in just a moment because there's one more Supreme Court case I want to look at. The third section, neither the United States nor any state shall infringe these rights without demonstrating that its governmental interest as applied to the person is of the highest order and not otherwise served. That's that strict judicial scrutiny. Highest order and not otherwise served it came out of the Yoder decision, and that's one way of wording that. A compelling governmental interest met by the least restrictive means is probably the most common. But highest order and not otherwise served is synonymous, it means the same thing. And we picked this one because there's nothing higher than the highest order. There never will be. If the Supreme Court ever decides there's something narrower than a compelling governmental interest, something else higher, we want that to apply, so the highest order interest. So that's why we use that language. And then the parental rights guaranteed by this article should not be denied or abridged on account of disability. Whether the child has a disability or the parent has a disability, they still have parental rights. If in some way their disability leads to neglect and you take care of the parent's disability and still there's neglect, you get involved for the neglect. But you don't just say, like some cases our friends at the National Federation of the Blind have dealt with, where nurses wouldn't allow a couple to take their newborn baby home because both parents were blind. And they just assume, oh, well, you're blind, you can't take care of your baby. Well, they have parental rights as well. Give them a chance, they take care of themselves just fine. They will, like every first-time parent, they will learn to take care of that baby too. So, so then the last Supreme Court case I want to tackle, and the reason I've saved it for last, it was just decided a couple of weeks ago. I guess it's been about 4 weeks ago now. In Mahmoud versus Taylor, it came out of Montgomery County, Maryland. That's the Baltimore area. And Montgomery County was, they incorporated a lot of LGBTQ books into the lowest grades of elementary school and across the curriculum. And so they were sued because at first they started to allow parents to opt their kids out, and then they backtracked on that, said, no, you can't opt your kids out because it's all through the curriculum. That's just too much of a headache, so you can't do that. We'll decide, and all kids need to learn this. And so they were sued by a Muslim family, a Jewish family, and a Catholic family. That's a pretty broad swath of American families. When you take it all together, this was not like, conservative, evangelical, whatever little corner of society. This was a broad range. And the Supreme Court sided with the parents. And one thing they said in that case was the right of parents to direct the religious upbringing of their children would be an empty promise if it did not follow those children into the public school classroom. They tackled the argument that we hear a lot, that, well, if you don't like what the public schools are teaching your kids, then homeschool, send them to private school. And the Supreme Court tackled the fact that a lot of people cannot practically afford that, and they feel their only choice is the public schools, and they should still have control over their children in the public schools, which, referring back to Section 2 of our amendment, the right to make reasonable decisions in public schools for your child. Not for every child, but for your child, sure. So Mahmoud v. Taylor backed that up. They cited the Yoder case a lot as well, which strengthens parental rights like they've not been strengthened since. Really, I feel the Troxel case kind of weakened them a bit. This strengthened them a bit, strengthened them back again, but really largely only for religious parents. So there's still work to do. So what's the Parental Rights Foundation doing? Well, we've been passing parents' bills of rights. This is one thing we've been doing. And that is a state law that lays out parents' rights in education, in medical situations, in CPS. And that is one area that doesn't always get, even though parents' bill of rights doesn't get all the detail that we want. I'll get to that in a moment because we have other models as well to tackle those things. But it generally establishes that parents have fundamental rights. The state should not intrude on them, the locality should not intrude on them, except for a compelling governmental interest. They can't otherwise be served. So we passed one in Florida in 2021. The ink had barely dried on it when Governor DeSantis used it, cited it, and said, under this law, I am signing this executive order pushing back on the national mask mandate, and we're going to look at starting to open Florida schools again. And all of that he became so famous for pushing back against the narrative and the federal mandates. He rooted it in the brand new Parents' Bill of Rights that they had just passed. that we were a big part of. So really proud of that win. We've also passed on in Montana, Georgia, in 2023, North Dakota, Iowa, Alabama, North Carolina, in 24, Tennessee, and then this year, Indiana and West Virginia. I want to say New Hampshire just passed a bill, a law also, that it isn't a full Parents' Bill of Rights, I don't think, but it covers a lot of those areas. So we're making progress in some states, in some areas of the law. Now, we also have model bills, and some of these, in addition to a Parents' Bill of Rights, Parents' Bill of Rights is different in every state. We have certain ingredients we're looking for. Parental rights are fundamental, they get strict scrutiny. We want a private right of action, so if you violate parents' rights, they can sue. So, we're looking for those ingredients, but it's going to look different in every state because it's going to use the language that already exists for that state. But we have model bills as well. One is the central registry due process. In some states, like in New York, if somebody calls in a report to CPS, the first step is they put your name on the central registry. Now that sounds really backwards. I guess in New York, it's just kind of understood that it means you've been accused as opposed to you've been convicted. But that's not really what a central registry is supposed to be for. I mean, if you go to the sexual offender registry, you know what that means. When you see a name on there, that's not somebody you want your kids hanging out with. When you see a parent's name on the child abuse central registry, you're going to think the same thing. There's a story, a friend of mine, Diane Redleaf, out of Illinois. She was a lawyer for a family. Their infant had broken bones. They got various medical opinions that said there's brittle bone disease going on here. There's a reason for this. Normal treatment led to these breaks. But the hospital they went to also had a child abuse pediatrician who said, there's no way this just has to be abuse. My biggest pet peeve is too small. It's too small a word. The thing that infuriates me most out of the entire realm of parental rights that we wrestle with is child abuse pediatricians. Because to a hammer, everything looks like a nail. And to child abuse pediatricians, everything that can possibly be abused. It's definitely abuse. It's definitely abuse. And I know, because I'm a child abuse pediatrician. And it's based on nothing. It's based on junk science and presuppositions and trying to diagnose a verdict in the court. So anyway, in this case, the child abuse pediatrician said, no, it's abuse. And the social worker agreed, and the social worker's supervisor agreed. And they went to court. The judge looked at the child abuse pediatrician's opinion and then all the other counter medical opinions. The judge concluded from all the evidence, said these parents did not abuse their child. They have a brittle child. They're starting treatments to take care of that now. Give them their baby back. So they gave them the baby back, and the next day, the CPS worker and her supervisor added the names to the child abuse registry. Because in Illinois, that was legal. That's what it took. It didn't matter if a judge had said otherwise. All it required was the social worker and their supervisor. If they agreed that, oh, this looks like abuse to us, they could put the name on the registry. So it took another 18 months and thousands of dollars in court costs for the parents to get their name removed based on the evidence that they already had that the judge had said they're not abusing their child. So our model would require, it would require first that parents get their name in court before their name goes on the central registry. Second, that if the judge says they're innocent, giving their baby back, that you cannot add their names to the registry. So some simple common sense things like that. Another one is medical investigations rights, and that's also dealing with child abuse pediatricians. And this one would guarantee that if a child abuse pediatrician is weighing in on one side, the parents they have a right to get a second medical opinion, and the courts will consider and weigh that second medical opinion. In some states, the judge only has to weigh one opinion, and so he can receive the second one. He doesn't have to pay any attention to it, and they don't. So that's what this tackles. The third one is confidential reporting. Because you guys have probably seen instances where, like a jilted ex, angry family member, somebody weaponizes the system, they call in and say, oh, so-and-so is abusing the child. It's especially in divorce situations, in a lot of places, the divorce is being settled in family court. And family court is where a child abuse allegation is going to go. So even though they're not supposed to influence one's not supposed to influence the other. But if dad wants the kids, then you'll call in and say, mom's abusing them. And the judges will hear about that. And then dad's got a leg up now in the custody decisions in the divorce court. So, and then they do that through anonymous reporting. So confidential reporting is, the reason we have anonymous reports is some people are violently abusive. And if the next door neighbor calls that in, they'll go from violently abusing their child to violently abusing the next door neighbor that called it in. So we want to keep it private. We want to keep it secret, but it doesn't have to be anonymous. The system can know. And that's why we call it confidential. Because they're not going to go tell the neighbor, who called them, but the system will know. So when there are false allegations, yes, we got an allegation that mom is abusing the kids, but it came from a dad who is currently in the middle of an ugly divorce. So we know that. So the confidential reporting anyway requires the state to get the name and contact information when a report is made. If it's an emergency report and they won't leave that information, then the state worker is to tell them, okay, I can't help you, dial 911, and then hang up. More model bills. Reasonable childhood independence, we got this one passed in Virginia this year. And it's passed in I think 8 or 9 other states as well. And this is simply a matter of if parents allow their kids to walk to school, they allow their kid to walk to the park and play. If it's age appropriate, if it's reasonably safe, then that is not neglect. Because we've gotten to a point in a society where anytime we see a child alone, somebody is going to immediately jump to, oh, that child is being neglected. Not necessarily. That child is learning and growing the way we did when we were kids. And when I was a young, I was going to say young teenager, but probably even before teens, like 10, 11, 12, we lived in a safe neighborhood. There were other kids in the neighborhood. We rode our bikes. And in the summertime, we'd eat breakfast and then leave the house, get on our bikes, ride all over the neighborhood with the neighborhood kids. And we had 2 rules. Be home at sunset and stay close enough that if mom whistles, you hear it and you come home. Because my mom had a loud whistle. We could probably ride a mile on that whistle. She didn't worry about us for the rest of the day. But the difference is nobody else did either. Nobody was calling the police and saying, oh, these children are out here and they're unsupervised and it's dangerous and somebody could kidnap them. So anyway, reasonable childhood independence simply narrows the definition of neglect to say that ain't it. That's not neglect. Family Miranda CPS reform is just, Texas passed this one, I think about 3 years ago, 2-3 years ago. Alabama's been working on it. And it's as simple as a piece of paper, but it tells you what your rights are right up front. So like that video that you just played a little while ago, Know Your Rights. It allows you to know your rights right up front. You don't have to talk to us. You don't have to let us in your house. There may be consequences, but but these are your rights. You can get a lawyer, all that. And so it's a simple. Texas satisfies it with a simple piece of paper. Because their Department of Child Welfare, when the bill was being discussed, they're like, "Oh, this is going to be impossible. It's going to keep us from doing our jobs. It's going to be so much work." And when it came down to it and it was passed into law, then suddenly it's like, oh, well, this piece of paper will take care of it. And suddenly it's so easy. So they hand a piece of paper at the beginning, the family can see their rights, know their rights, and then CPS can continue on with their investigation appropriately with the parents knowing their rights up front. And then another model that we have is simply fundamental parental rights. It's just as simple as parental rights are fundamental, and the courts need to protect them with strict judicial scrutiny. We passed one of these in Virginia back in 2014, which Glenn Youngkin used to very positive effect when he was running for governor a few years ago. because he pointed out, said, it's actually a law in the Commonwealth, the parents' rights are fundamental. And he was citing a law that we got passed in 2014. Now, this is a lifeboat from the Titanic. And why do I use this? Because parental rights matter to all of us. I have the pleasure of working across the aisle with Democrats, Republicans, super conservatives, super liberals, men, women, black, white, brown, every shade. With all these different issues, parentalrights.org was founded by conservative Christians concerned about their right to homeschool. But so much of our work today is trying to deal with CPS issues that disproportionately affect poor people and minorities, and single moms in the ghetto who would never cross their mind to homeschool. That's not their concern. Their concern is they want to be able to still work their 2 or 3 jobs that they have to work to keep food on the table, and not have their kids taken away because the neighbor across the hall is watching them when they get home from school. And so the thing we have to recognize is it's so easy in our political climate to say, well, this is our interest and that's your interest. You take care of your interest. We'll take care of ours. I'm not real worried about it. I'm sorry, but I'm so worried about what I'm going through. I'm not worried about what you're going through. But we are all in the same boat. When it comes to parental rights, if we can defend parental rights as that fundamental right that the government should not tread upon, should not take lightly, should not just dismiss, then we are all protected by that. And yes, I'm going to focus on the holes in my end of the boat because this is where I am. I'm going to fight where I can fight, and you fight where you can fight. But we need to recognize that we're in it together and support one another. That all parents are in the same boat. So I call this talk "The Strengths and Weaknesses of Parental Rights in America." And so here are some of the strengths. First, we have 100 and more years of Supreme Court precedent that say parental rights are fundamental. Centuries of common law precedent before that, before it ever reached the Supreme Court. It was just a matter of common law. The governments don't interfere in the family. Parents take care of their kids. Parents make the decisions for their kids. And that goes back centuries. Now, we have a growing list of states with legislation. I think we're up to 29 states now that have some form of parental rights statute. And they're not all Parents' Bill of Rights. They're not all, I wouldn't give them all a grade A, but 29 states, at least they're getting a D, at least they're getting a passing grade in terms of having some law that protects parents' rights. And that number is growing every year. And there are continuing efforts at every level to secure these rights, local level, state level, and federal level. And probably the biggest strength is that parents are perhaps more awake now than ever. Ever since COVID, in particular, parents are wide awake to some of the stuff that the government's been doing with their kids, and some of the liberties that the government's been taking with their kids. And parents are like, wait a second, I'm still mom, I'm still dad, these are my kids, and no, you're not going to do that. In the CPS realm, I think social media has helped a lot as well, because it used to be, and it still is, too much. But like 20 years ago, the automatic assumption was if CPS came to your door, oh, well, you must have done something wrong. There must have been something. But with social media and us people being able to get their stories out, more and more we recognize that 80%, more than 80%, nationwide is like 83%, and it's been sitting at that figure. These are annual figures. It's been sitting at that figure for about 10 or 12 years. 83% of all CPS cases are closed as unfounded or unsubstantiated. So that's 5 out of every 6. Where, guess what? No, we didn't do anything wrong. Nobody did anything wrong. They gave the kids back, or they finally closed the file and never took the kids. 5 out of every 6. And so people are beginning to realize that just because CPS is at the neighbor's door does not mean they never did anything wrong. So we're starting to learn that and become awake to that as well. But there are some weaknesses. Supreme Court precedent isn't as strong as we'd like. The Troxel v. Granville decision of some special weight, that's not enough. And now the Mahmoud v. Taylor decision from June 27th, I think, or June 25th, that strengthens that again, but only in the areas of religious upbringing for religious parents. So there's still some work to do there. There's no mention of parental rights in the text of the Constitution. We struggle with maintaining Second Amendment rights, and it's right there in black and white, right? We struggle sometimes with our freedom of speech, freedom of religion. It's right there in black and white. Parental rights are not mentioned, so we want to fix that. There's also the fact that there are some stubborn states who will never pass the Parents' Bill of Rights. They're just never going to do that. Now this is an interesting little tidbit that I find kind of interesting. The confidential reporting model that I mentioned before, Texas passed it 2 or 3 years ago. One other state legislature has passed it, and that's New York. New York and Texas. That's an interesting pairing. But they both passed it. Now, the New York governor hasn't had the opportunity to sign it yet, but the legislature has passed it, and hopefully the governor will sign it. But there are some states that will never defend parents' rights. And then sadly, opponents of parental rights are deeply entrenched and well-funded. Basically, if there's an organization or institution that makes a lot of money off of your kids, especially off of things they can get your kids to sign up for and pay for that without, that you would have told them, no, this is a good idea, then they're going to oppose parental rights. CPS, the institutions, the agencies want things to stay as they are because they don't want more hoops that they have to jump through. They're okay with all the hoops you have to jump through and don't really care too much about the damage to your kids. The National Education Association, they want control of the kids because when parents get involved, and this tough thing is the more parents are involved in their child's education, the better the outcomes. We all know that, they know that. But the more the parents are involved in their child's education, the less control the ADA has and the fewer things they can get away with. And so they're opposed to that, and other groups as well. So family courts, and this is a big weakness and the one that has gathered you guys here today most of all, is that family courts play by a different set of rules. So even though the Supreme Court has made it perfectly clear that parental rights are fundamental, family courts just, if you want those rights, well, you're going to have to appeal. In too many cases. So then what can we do? Well, let me encourage anybody who's looking, you can find our models on our website and promote them to your state lawmakers. The models, it's at parentalrightsfoundation.org, and across the top menu, one of the options is models. Just click on that, find the model that you think you're most passionate about and that would be make a most powerful change in your state. And then talk to your state lawmakers about it and say, hey, can we pass this in our state? And you can also sign up at parentalrightsfoundation.org to get on our mailing list. We send out updates about once a week. If we don't have an update, we don't send it. But also during the legislative year, we can send out updates, we can send out alerts. For instance, if Virginia were working on, like this past year when Virginia was working on that bill, the Reasonable Childhood Independence Bill, it got slowed down in committee. We sent out an email to all our people in Virginia and said, hey, encourage your state senator to vote in favor of this and get it out of committee so that it can pass. And that's not a weekly thing. That's a when it's necessary, when it's needed kind of thing. So you can sign up for those. It's the same list, parentalrightsfoundation.org. And then if you're in a position to do so, donate to educate. Just support the Parental Rights Foundation, it's a nonprofit, and help us to educate other people as well. So that's what we do, and that's how you can help. Help us get the word out and help us get these laws passed. And again, I realize that if you're already dealing with CPS, one more thing to do. This is brand new. But we've just put together a list of legal resources. With our name, people contact us all the time saying, I'm having trouble with CPS, can you help? And as I said at the very beginning, we're not a law firm, we don't have lawyers, we can't help. But we really want to help. So we've been trying for years to have somebody where we can say, well, what state are you in? Okay, well, here's somebody we know. And too often, unfortunately, I'll say, oh, well, I don't know anybody in that state, so I can't help. But we've put together a list now, so if people reach out to us, say I'm in Idaho and I don't know who to call. Well, here's a link for public defender or whatever it might be, family court, law firm there that might be able to help you. And we're not connected with them, we're not associated with them, we don't get any kind of kickback if they get hired or anything like that. It's just we want to be able to tell people, we can't help you, but let us point you in the right direction. So that's one more thing that we're doing at the Criminal Rights Foundation. The biggest thing is, by and large, we're not a help, and I recognize that, to people who are already in the system and going through it right now. But working together, we can change the law so that tomorrow, somebody else in the same situation in their family doesn't end up in the same situation in family court, doesn't end up in CPS. So we're working on changing the law beforehand, and encourage you to join us. Help us do it. Thank you. Yeah, other questions?
Does anybody have any questions? Darren, anybody online have questions? I can't read that.
Are there cases that us parents can use while fighting for our children that point out the parental and fundamental rights?
He just answered that. You might have to go back and watch it, Alicia, or I can send you.
Yeah. Well, I can tell you a couple right off if you want to jot them down. I don't know how helpful they're going to be in family court, to be honest, because a lot of judges pretend that doesn't apply here. But the first two are Meyer versus Nebraska, 1923, and Pierce versus Society Sisters, 1925. Those are U.S. Supreme Court cases. Wisconsin versus Yoder from 1972. Another one that's a favorite of mine that wasn't in my talk is Parent versus J.R. in 1979. And then Truxell v. Granville in 2000. And if it's dealing with religious upbringing and decisions of that sort in the public schools, then the Nachman v. Taylor case from just this year would be a good one as well. But another thing to do is you might look for those in your state. And what you can do is go to parentalrights.org/ and then enter the 2-letter abbreviation for your state. That'll take you to a state-specific page. So for instance, parentalrights.org/MD will take you to Maryland. And on that page, there's a summary of Maryland law, and there's a summary of Maryland court cases. So if you were in Maryland, you could name these Supreme Court cases from the U.S. Supreme Court, but you can also look at Maryland court cases, if there are any, that support parental rights as fundamental, so that could help as well.
I don't know how people can try to get this starting just because of how many programs are the truth about things and how.
That's what they do.
No, but
Yeah.
she's asking that. It's a violation. They technically legally can't do that, but
Right.
you should get it.
Yeah. So this next question, I want to know how anyone can try and get my visits terminated just because I tell my 8-year-old daughter the truth about things, and how I do goes against a therapist. Legally they can't. The parent has that like I quoted from that Wisconsin versus Yoder case, the primary role of parents in the upbringing and education of their children is established beyond debate and enduring American tradition. Parents come first, and the parents have that decision. Now, if they get a court order, I mean, if the therapist is, if there's a reason that a judge has said that, this therapist is right, the parent is wrong, this is abusive, then that's different. But you're supposed to legally get your day in court before that happens. And I need to mention here too, I'm not giving legal advice, I'm not a lawyer.
We already put that on there.
Yes, I know, I've seen that running across the bottom. I want to make sure you understand that that's not just Tiffany and the Punisher, but that's me as well. I'm not a lawyer. I hope this is informational for you, but I'm not giving legal advice. But from my understanding of court cases and so forth, they do not have the power to do that unless you get your day in court first.
Coercion, threatening, intimidation, and retaliation.
Yes.
All federal law.
That's all federal. That's all federal. We have those cases. We're going to go over them, but not today. Actually, I'm going to send you the cases too, because I think they might help you. Anyway, you need to take me to Congress with you. Yes. So I'm going to come up here with Mr. Ramey. First of all, thank you so much. Oh my God, I appreciate you so much. And I know our viewers do, and even the people that turn the show up. Oh my God, we're gonna be doing a lot more work together. If anybody, Darren has put up the website online. We've been talking about this. This is not the first time we put their website up. And make sure you sign up for the emails. Every time I go on their website, it asks me, my name's probably in there 1,000 times. I'm never gonna lie.
Actually, no, it's not. And this is,
Oh.
tell your audience this too. This is a good thing. So, because it will automatically be you. So if you're not sure if you've signed up before or not, go ahead and sign up. And if you have, it'll match and recognize it's the same one. And you won't be cluttering our database. But that way you can make sure we have you and you're on our list.
Well, that's good because I thought I was cluttering it up.
No.
But that's just how I am. But there's a lot of good information on there, right? When I came across them, I've been on your website for a while. I'm pretty sure as long as it's been up. Because I stumbled upon it. I'm like, oh my God, there's somebody else out there like me, but they're just an organization. So everybody needs to go to this. Everybody online, everybody. Now, will he personally be able to contact you? Maybe. I don't know. His email address is on there. I'm sorry. I didn't mean to do that to you. Does anybody else have any more questions for him? Send that to me too. We have a whole packet online. If you go, Darren put our website up so that they can see where they can get the packets for the people that didn't show up, because we're getting ready to go over another piece of paper. The girls want me just to go over the paperwork one more time. Oh, no, thank you. You need to take me to Congress. I'm gonna stand. Oh my, I told y'all he was taller than me. Okay. So again, Darren, if you can put up the warning for the kids that are going to be going to school, because I want everybody to get a copy of this. So make sure that you go to cpsbreakingnews.com. Oh, and then at the bottom of the screen is parentalrightsfoundation.org. Make sure everybody goes on there. And we're just waiting on Darren.
We're always waiting on Darren. We love you though.
And I hope everybody enjoyed Mr. Ramey, because let me tell you, I did. Okay, so this is our website. And in the packet, we have the warning again for anybody who came in late. The warning for school that you're gonna cut out, put together, and laminate it. But make sure that you put your name and phone number on this for your children, because remember, the schools contract with CPS, the hospitals, the doctors, everybody contracts with CPS except for parents. The next thing is the Declaration of Truth. And when you fill this out, yeah, there's your warning. Right. And right there at the bottom is where you're going to put your name. So like I said in the beginning, you're going to put your name and information on there. If your child is just now going to school, you won't have a student number for a couple weeks. So you don't have to put the student number or their social security number on there. But when I did mine, I put my name, my address, the school name, and I had it notarized. And you have to send this to, you have to send this to the Board of Education in your state. Ours is Richmond in Virginia. You have to send it to your local school board, which is mine is Frederick County, Virginia. And you have to give this to the principal so that nobody can talk to your child without you being present. And I don't care who they are. And it clearly states on here, School officials, police officers, child protective agents have no authority under any color of law to speak to my children without me being present. So you need to make sure that you get these in, because this paper can be the difference between your children leaving school and coming home or being taken and put into foster care. Now, the other paper is one of my favorites. Darren, I don't know if you can find it, but I didn't know we were going to talk about it. It's the color of law form. I have 400 copies of this, and I threaten to sue people all the time, and I threaten to serve them with color of law form, and they leave me alone. So in color of law form, I actually just helped a couple in Tennessee and Kentucky with this. At the top of the color of law form, you're going to put your address, your name. On the other side, you're going to put, I've actually had CPS/foster care, the entire department, served with the color of law form in 2 different states. And on here, it says your citizen statement. Under your citizen statement, you need to first know what your rights are. Let's just put it out there. So I had to tell them what their rights were, and I had to explain what their rights were. So the First Amendment right also covers you in, your First Amendment says you have the right to associate with your own children, your family, your friends, whatever the case may be. So that's the first right that they violated. The second is your Fourth Amendment right, because there is a case that, and I don't have it with me, but it was clearly established that a child seized by the Department of Child Protective Services without a warrant is an absolute unlawful detainer and seizure under the Fourth Amendment. So you have to put your Fourth Amendment right on there, because even though children don't have per se, can't really say anything because child under 18 can't even sign a contract. You as the parent hold those rights, right? You're their spokesperson, you're their advocate, just like I'm an advocate for other people. So you have to put your Fourth Amendment right on there. Also, please put your Fifth Amendment right. That means you don't want to talk to these people, so you're remaining silent. You also want to put your 14th Amendment right on there, your due process and equal protection under the law. And that also falls under the Fifth Amendment. So when CPS or the county or whomever it may be violates your rights, this is a legal warning, and at the bottom it says you must cease and desist, period. And make sure that whoever serves it puts their name and what time it was served, because this is now a legal federal paper, okay? The states don't really like these papers because they're just going to throw them out, but the federal government will. And the color of law means you abused your power. You took authority over somebody you had no authority over. So this is a fun little form, and I absolutely just love it. The other one we have, these are just for my area. So if you're online, you'll have to look up, and I can help you with that. I hand out complaints from the NAACP. I hand out their complaint forms. I am their legal redress chair here. Every complaint that comes into the NAACP, it either comes to me or the Criminal Justice Board. So file your complaints. The more complaints that we have, the more the state and the nationals will get involved. Pretty much we have to show a pattern. The other complaint form we have is to the Ombudsman. Now, I know some of you all know Eric Reynolds. Eric Reynolds, he is the Ombudsman. We all wish that he took the power, have taken the power that he should have taken when we were trying to give it to him, but that's neither here nor there. So in Virginia, Eric Reynolds is our Ombudsman, and you can go right online and find the complaint form. And if you're having a problem with CPS or foster care, you absolutely need to have a paper trail, and you need to file a complaint with the Office of the Ombudsman. Now, we all know that and Mr. Ramey just said it himself, they're kind of like, when you bring up case law, but the Constitution is clear about all judges have to take an oath, they have to, they have to do this. But anyway, when they don't, in Virginia, there is a complaint form that you can get offline, and it's very simple. You put the judge's name, the location of the court, the date of the incident, your case number, if you know it, the status of your case, your phone number, and anybody who witnessed this. I tell people, we all know they're not going to do anything because we have judges judging judges and police judging and CPS. They're all policing themselves, but it doesn't matter. There's a paper trail, and we need paper trails because paper trails are hard to get rid of unless they're throwing them in the trash. As for the attorneys, I don't know if a lot of you all know this, but I did advocate for attorneys in 2023, I believe, for them to get more money because I said, well, maybe if they get more money, they'll actually do their job and protect parents and children from the courts. But that didn't happen. So anyway, so there is a local bar and there is a state bar. So every state has a bar where you can go to their website and download a complaint form. Now, in other states, I've never had it happen here, but in other states, I have helped people file their complaints against their lawyers. And actually, the ones that did file their complaints and actually paid money, the bar association in that state made the lawyer refund the money. So there's always a chance that you could get your money back. So you definitely want to file a complaint, and don't file a complaint if it's not true, because the one thing you never ever want to lose is your credibility. Once your credibility is shot, nobody's going to believe you, ever. So that's what we have here in Virginia, and most of the people online, they already know who I am, but they can email us, and Darren and I can send out forms for them. And if nobody else has any questions, anybody online? Darren, how you doing, Darren?
Do you want to state your website name and stuff of your?
So our website, there's Darren. Darren, you gonna come on and speak? Our website is cpsbreakingnews.com. cpsbreakingnews.com. We're also on YouTube as Tiff and the Punisher. We're on Facebook when we go live. We're on Facebook, Rumble. We're on a lot of platforms. I can't remember all of them. Except go ahead, Darren. You got anything to say?
No, we're on. Yeah, we got cpsbreakingnews.com. That has blogs. That's got all kinds of things. It's under construction, so we're working on that. So be cautious. But I just put up. So I have a whole. It's a 203-page explanation of the rights under the color of law that will include with that. It's the entire breakdown. That's what I was showing you guys up here. So we'll submit that with you. It's the entire thing. That way you know how to. Because one of the questions were, and Henry answered it. Which don't forget to watch Henry's show tonight, guys. Equal and the Same at 8 o'clock. It's his new show for the ADA. But his question was, what happens if your CPS already has your kids? Can you still charge people under the color of law? Is that, Tiff, how does that work? Can you still serve people under the color of law if they already have your kids?
If they already have your kids, it's too late.
It's too late.
It's too late. You want to serve everybody before that happens. Because once these people get their hands on your children, all they are is a dollar sign. And once those dollars come rolling in, the guy that's coming on this week has already said it. They're going to roll out everything and make it longer, because as long as the money's coming in, they're not giving up that child.
Right.
It's too late.
All right. Let's see. So Renee says, they've kept me from my kids, and even the judge said rights are to continue, yet haven't seen my kids in over a month.
It said what? I couldn't hear you.
It says, Renee says that the judge has even said that she should be able to continue with her kids, yet she has not been able to see her kids for over a month. So in those cases, what do we do? Maybe that's a question for the parental rights um, gentleman.
Would
If
you
he's
like
still
me
there.
to? He's coming up.
All right.
Yeah, right there.
Yeah, so again, I'm not a lawyer, so I can't give you legal advice, but I can advise you to talk to a lawyer, because it seems to me that that they're in contempt. If the judge has said that you have your rights back, and they're not giving you your child back, then there should be something you can do, because they are in contempt of the judge's order, the judge's decision. Again, I'm not a lawyer, I can't give you that legal advice, but hopefully your lawyer.
So we're seeing a lot of this, though. We're seeing a lot of visitations being disrupted by CPS, but we all know that the judges are the only ones that can terminate a visitation, right? But yet, even when the judges are saying, "Hey, these people can visit," they're not abiding by it. And so, what can parents do? I mean, I know they can go see a lawyer, but is there any other redress that a parent can do when no one's listening to them at all?
Well, unfortunately, like I said in my talk, it's been my experience that family courts just kind of operate under a whole different set of rules. We're
Right.
trying to fix the law to rein that in. But as it is right now, if you get a bad judge, until you're ready to spend a lot of money on a lawyer to appeal, and you can't appeal until the first round is concluded, then you're kind of stuck. And parents ought not to be stuck, but we are. So we are working on trying to fix that, but I don't have any magic bullet that I can offer at this point.
Right. I mean, it's more so that parents are stuck. These kids are the ones that are stuck. Like that's, and I think that's where maybe if we just played the urgency of the children and the damage that it's doing to the children mentally, physically, and all of that, maybe we could get a sense of urgency, because it doesn't seem like the courts or anybody really cares about us as being parents. But there's not a mass of us. Don't you agree that we need a mass of us parents to come together to show that there are so many of us that they need to make a change?
Yeah, I mean, we just keep working together, coming together, and then trying to make these policy changes and these legal changes like we're doing with our organization. And we're not the only ones. We work in cooperation with other organizations as well, from both sides of the political aisle. And we're starting to make some changes, hopefully in Congress. So, but again, CPS, that whole machine pushing back, it's a huge machine. We're starting to change the discussion, change the dialogue, and that's really kind of where we have to start. So I don't know what the critical mass is, but I do agree with you that the more of us there are, that we will eventually hit a point of critical mass wherever it is, where we will start to see things getting done.
All right. And my last question to you is this, and I don't mean to point a loaded gun at you, but do you feel that working towards changing legislation and changing what's going on with the current situation is the ideal way to go? Or do you feel like just abolishing and destroying this whole system, starting over, would be the way to
go? Our position as an organization is not at abolishing at this point, but I'll be honest with you on a personal level, if the system gets abolished, I will not cry over it. Our strategic position as an organization is if we can make incremental change, then we'll take incremental change until we've made radical change. So we are not at all opposed to the abolition movement, not in the least. Hey, if you can abolish it, great. Meanwhile, we're going to try to take every inch that we can get when we think we can get it. So that's kind of our strategy. It's not about that we're opposed to abolition of the system at all, because we're not. But I also can't claim that we're working toward abolition of the system. I think that would be trying to take more credit than what we're doing, or different credit than what we're doing. We're trying to be strategic and grab the wins we can get.
Excellent. Well, thank you very much for everything that you've done today and coming out and all of that. I really do appreciate it. I really do.
Thank you. Yeah.
Looks like we're clear up there.
There was one question that Harry said. He wanted to know if your organization can look into seeing about medical groups that are doing studies for kids. I think that's what it said. I don't have my glasses on. It's this one right here. Hold on, Henry, I'm finding out. I guess like you did with the attorneys or the people, the new thing you guys just started.
Yeah.
He's coming.
Sorry, yeah, this is not a direct answer to that, and I recognize that, so I apologize for that. But let me tell you about a podcast that we've got. It's the Epic Broadcast. Epic is spelled with an extra P. It's EPPIC. And the reason we misspelled it is it stands for Empowering Parents, Protecting Children. It comes out every Tuesday, 2 o'clock, wherever you find podcasts. The Epic Broadcast. We have seasons and off season. Right now it's off season, but you can find all of our past episodes on there. New episodes start back in September, run for 3 months. So it's 3 months on, 3 months off. And I host it, and I don't think I'm really the world's greatest host, but I'm very proud of the guests that we've had on there through the years. And these are experts. Some of them are lawyers, some of them are legal scholars, some of them are academics, and some of them are parents who've been through it. But the thing these lawyers and these academics have in common and bring to the table is that kind of research that demonstrates that, CPS taking children out of the home damages the children, damages the parents. It's causing a lot of, bad things, a lot of trauma that's unnecessary. I mentioned before the 83% of cases are closed as unfounded or unsubstantiated. That's 5 out of 6, and every one of them involves some kind of trauma, some kind of making the parents look less authoritative and less powerful in the eyes of their children, which robs the children of a sense of security, robs the children of stability. And when 5 out of 6 of them are unnecessary, we really need to correct that. We don't want to keep the system from finding the kids who really need the help. We want to keep them from wasting their time on families that don't need interruption, so that they can spend their time finding the kids who really need the help. Everybody wins that way. So anyway, through that Epic Broadcast, again, EPPIC, Epic Broadcast, there are scholars on there tackling some of those issues, some of those questions, providing some research and some insight into, how keeping families together is better and healthier for children.
Absolutely, and I'm gonna make sure I'm on that podcast. I'm gonna listen to that podcast. You said September?
Yes.
I'm signing up. Can you sign up?
No, but if you're getting our emails, we'll highlight
send it
we'll highlight it when the season starts.
All right, Darren, if there's nothing else, we're gonna sign off for now, because I know you got another show to do, and I gotta go pick up my brother. I guess he's on the phone.
Always waiting on him.
I know.
Oh, yes, you did.
Grow up.
Okay, so anyway, we will be back on Monday with Tiff and the Punisher, and I'm gonna see if Mr. Rainey would like to come on live on Monday, because we are trying to get Mark Warner to come on. Haven't heard back yet. I did send him an email, so I'm still working on the Mark Warner thing for Virginia, like I said on Friday. But I'm gonna see if Mr. Rainey can. Yeah, that's right. They're laughing at Darren right now. Can come on Monday, and because he was here in person, if we can bring him on the podcast, and the people, instead of looking at the screen that's kind of waving around, can ask him more detailed questions if they want. So with that, I'm gonna let Darren end the show, but I will see you guys back on Monday, and Darren, I will call you when you get off your phone. You're welcome, guys. Love you. We're leaving. Yes.
Has a thing to say for those who have been isolated. They are taking our kids every day. A child a minute, no one has a thing to say for those who have been isolated. Don't be worried, you have a voice today. So listen up everyone, here is the story. Child Protective Services is real. CPS is what they call it. They want our kids because it fills a lot of people's wallet. We all think it won't be us. We say when they come we will be so tough. It all sounds good when there's no one to take them. But when they come, your voice gets to breaking. Stay calm, step away. CPS ain't taking no one today. We are educated. Stay calm, step away. CPS, you need to leave. I know the tricks up your sleeve. You can't do what you're trying to do. We have done our homework. Don't do a damn thing without a warrant. You know the number. We'll steal our kids this way. Tiff and the Punisher have come for the calling. They are giving us the CPS warning. Their voice is loud and clear. We stop losing our kids this year. Tiff wants to fight the entire planet. She is tired of our kids being taken, God damn it. She's been fighting CPS for 30 years, bringing children home from this disgusting mess. The Punisher is screaming out loud, abolish CPS and tear it down. I want all our kids to come back. Look at all those kids' pictures held up like thin tags. Together we are stronger than we need. We will tear down CPS with high speed. We will do so much being together. Birds of a feather flock together. So watch out CPS, here we come. Picking you one by one. We promise